Dear students of Ukrainian-American Concordia University, I welcome you to the lecture of aspects of law and sales contract. But first of all, I'm very sorry that you have not the chance to do that live with me, because that would be more interactive than in that way. But I try to do my best that you have a chance to follow my lecture and to gain some knowledge. Let me introduce myself. So I studied economics at the university in Mainz here in Germany many years ago. And after these studies, I made a trainee program in a bank with two special departments. The one was the trading department, and I was in that case also a trader at the Frankfurt Stock Exchange. But the other one was the international department, and at least I joined the international department of that bank. That was the Central Institute of the Cooperative Sector. And then these guys sent me to a local cooperative bank to build up a new international department there. What I've done at that cooperative bank else was the treasury and also the private banking. After many years of banking, I decided to join university. So I'm now, since 15 years, a professor at Worms University of Applied Sciences with the professorship of economics, foreign trade consulting, and financing foreign trade. And the topic here, aspects of law and sales contract, is very near the international business of companies, because we have here not to look on Ukrainian law, on German law or so, but how to deal with law in the international context. But other remarks concerning this lecture. So my aim is that you have some fundamental knowledges on these international aspects of law. I decided to do that in 4 parts. So I will record that here the first one, then you will see 3 others, and I will do that separately. Usually we came into a discussion with breakout rooms or so, but in that case, I'm sorry that it is not possible. So I will ask some questions, give you some time. You can stop the recording, the video, and then answer the question by yourself before it goes on, and I do a little break that you have the chance to stop if you're interested in to make your own thoughts on the topic or my question. What else? Today, the 4 parts today are really short. Or let me better say, my presentation is not as long as it can be. Because of what? I will send you, after this lecture, a sales contract. That is a sales contract which a German company has signed with a Chinese one. And my question then is, or your task, I should better say, your task is to look for that sales contract, if it's a sales contract which you would have also signed or not, or which are the critical points. And I promise you, you can do with some certain knowledge of this lecture. So that will be the task, because you have to read some pages. I think it should be around 7 pages written in English. So then let's start with the presentation today. So what I want to do with you to show you some aspects of law and sales contract. In every case, in the international context, so international trade law, and you will see what that means, some selected so-called Incoterms. So I divided my lecture in 4 parts: aspects of law, sales contract, which I have to put at the end here now, the Incoterms, and then some other rules which should be, or which are usually applicable for international trade. So then let's start with aspects of law. This I can't do with you, the Pingo questionnaire, so please ignore that. We will go on with the agreements in a sales contract. And the question here is that you should or would do some decisions. What are the decisions, the main decisions? The first, what is the applicable law? Which law should be the one you choose for any decision in your sales contract or any, let's say, dispute? Would you like to take the law of the home country? Or you are in negotiation with the partner in the other country? Will the partner take his law and you accept? That means at the end, the law of the foreign country? Or because you as a export importer and the other party in the foreign country can't decide to take one of these, you take a third country law. And here, very often, the Swiss law is taken. Because of what? Switzerland is a neutral country, and very often it's assumed that therefore the law is also neutral. But believe me, that isn't the case. It's very close to the German law. But there are some other opportunities. Arbitration. I don't know if you have ever heard of an arbitration. Let's start in another way. If you have a dispute with your partner in the other country, you usually will go to court. Then the judge will decide which party has right. That is usually not an expert in your business. And it's sometimes with a revision and a second level, third level, and so on. It takes, therefore, often a very long time. Arbitration means that you decide which arbitrator, which judge you take. It might be an expert. It might be not only one, because if you think on the case with the 2 countries, with the trading partner, you will perhaps take 3 or 5, very often with an unequal number, because then you have a clear decision and not a pat. And that is usually also then the very last decision. this arbitration. I will send you the whole presentation, an original one. Then you can do here, click the link on arbitration, and you will find there some more information on how arbitration is done or you can deal with. But that's not all. We have a fifth opportunity. The United Nations have developed also a convention on international sales and goods contract. That's called the UNCITRAL or CISG. That's a special law for international sales contracts. And at least there are more rules. We will talk about these rules later. These rules are not really a law, not an applicable law in your sales contract, but rules which very often are used in international business. Here are other rules. If you have not chosen the applicable law, that might be you have not talking about law of home country, not law of foreign country, nor of a third country. You have not filled in arbitration and also not the CISG. Then the court or the judge has to decide which is the applicable law, and that can be the decision followed by where has the contract to be fulfilled. The next question, can you really clearly say where the contract has to be fulfilled? Is that the payment? Is that the delivery? Which is the fact fulfilling the contract? Or the other one, where the goods are at that certain moment? Or where the contract is signed? And here we'll see the next problem, because contract might be signed first in the foreign country and then you're signing in your own country, or the other way around. When is really the contract signed? Was the first or was the second signature? Is that really clear? So you see, then you have many unclear situations, and therefore I can only recommend to use one of the first, these 5 opportunities: home country, foreign country, third country, arbitration, or using the UN Convention. Here, some parts I took from the United Nations. You can really read, I will not read it here for you. You have enough time. You can stop the video here and read by yourself. So once again, we will look for the CISG, or United Nations Convention on Contracts, or the international sale of goods. And I will tell you why that part is important. Look on the member states, or the states ratifying this convention, this CISG. And that's the last one I found in the internet. Might be that there is another member state now, but the problem you'll see. These are the actual member states. That's the very last one. And you can see also that it's in alphabetical order, and you see that Ukraine is a member state. Now, the question. What is the applicable law if you have not chosen any law in your sales contract? You have not decided for home country, not for foreign country, and so on, and also not for the CISG. You are the partner in the Ukraine, the other partner might be in, let's say, in Germany. Then both countries are the member states of this CISG, and therefore automatically this United Nations Convention is applicable for your sales contract. Also, if you have not decided for that one, it's automatically chosen. So that is the main aspect why it's so interesting to look for that United Nations Convention. Here are some more aspects. You can click on the home country if you have the original presentation from my side. Then I hope you can answer now the question, why is the list so important? Can you? Second question, what's with the United Kingdom? So list is important because it's automatically the applicable law if you have not chosen the law in your sales contract, and both countries are the member states. And United Kingdom has not ratified, so it's not a member state at the moment, really not a member state. These are the main parts of these CISG or United Nations Convention. You will see in part one, the sphere of application, some general provisions, how formation of the sales contract is done in part two, what is the sale of goods in the part three, and some final provisions in part four. We'll not discuss that here in detail because that is not the interesting point here in that overview. Then let's ask, what are some advantages or disadvantages if you choose one of these opportunities, the different opportunities for the applicable law? If you look, for example, for the home country law, what is the advantage? And what is the disadvantage? So I can only say from my point of view, and I've done the business very long, there is not one case comparable to the other. But if you choose, for example, the home country law, and really also you reach that in the case of dispute, your partner in the other country is here in front of the court, in the Ukraine or in wherever. And you have also the decision in your sense. You have the right on your side. The next question is, can this decision be executed or not in the other country? And not in every case, a decision of one country is to be executed or can be executed in the other country. So if you have chosen your home country law and it's not possible to execute the decision, then you have not reached anything. So therefore, it can be of an advantage if you choose the foreign country law, because then you know decision will be executed in that country. But it can be a disadvantage in so far as you don't know this law as good as your home country law. But in the case of dispute, you also do not know which case it will be and which of these two, or if you take also the neutral country, the third country law, you will not know which might be the best law for your dispute. So please ignore once again my question here in Pingo. As I told you before, the first problem, when is a contract signed? Now here the question is, when is a contract really concluded? When we have some differences in laws, I can only give you some examples here. And to be honest, I'm not familiar with the Ukrainian law, but in Germany, contract is concluded if you accept an offer. It means the one party is offering you to buy a certain product at a certain price. And you accept it. And you say, yes, I will. Then the contract is really concluded. Not physically signed, but concluded. It might be in the supermarket, bakery shop. Baker is offering you the bread at a certain price. And if you give them money for that bread, then the contract is concluded. That's a little bit different if you go to the UK. There you have offer and you're not denied to the offer, then also the contract is concluded. You see, there is a difference between these two countries. And as I said, I'm not familiar with the Ukrainian law, but perhaps you have the chance to check. What about the language? Will you choose Ukrainian language? Will you choose English? Or if you have a trading partner, let's say in Mexico, will you choose Spanish? Usually, yes. Mostly, which language is chosen? English, for sure. But also in that case, sometimes it's a little bit critical, because it can be that the court says you're not really familiar with the certain expressions in that language, and therefore you couldn't understand what you signed. Might be a problem. Oh, I go back one slide, excuse me for that. I had also the case of a company, and that company has exported to Saudi Arabia. And the importer in Saudi Arabia has developed the sales contract in Arab language. And be sure, this German exporter couldn't read it. And for sure also not understand what he signed. Therefore, he said, I want to have a translation into English. And that was made, yes. But can there be any difference between the original Arab language and the English one? Yes, for sure. And if you then accept that in the case of dispute, the only language which is, I caught a cold and therefore I'm not as concentrated as I should be. So in that case, the Arab language is the only language in the case of dispute, which is be accepted. So that is perhaps a problem. We don't know if it will be a problem. As I said, sales contract, I will skip here and will give you the task to look for that sales contract. I'll send it to you, and that is a real sales contract signed by a German company for an export of a machinery to China. And if you think only on with your knowledge you have, then please look for some critical points. Let me know the critical points. Send it to me so that I know what you have seen as a critical point, and I will do that in a second part of the lecture, not today, but usually it had to be in 1 week. But I'll send also a video then. So I will tell you what I see as a critical point in that sales contract. But please read it before, make your own thoughts on that. And I believe, and I'm really sure that you can do that very, very good. So that is my first part of the lecture. I will do the second in a separate video, the Incoterms, and then the last one with the other applicable rules. So many thanks so far, and hope to see you again.